Supreme Court has now upheld the stringent provisions of the Prevention of Money Laundering Act in relation to the expansive definition of proceeds of crime and seizure, power of arrest, attachment of properties, as well as twin bail conditions. Now, the PMLA provisions, they say, do not suffer from any arbitrariness. So this is a big fillip for both the Enforcement Directorate as well as the Government of India, which had very strongly defended the amendments made to the PMLA Act in 2018, something that a series of petitioners, including those who've been at the receiving end of PMLA cases, had challenged for what they called their unconstitutionality as well as their arbitrariness. The Supreme Court has in fact given a big fillip to both the investigative agency in this case, which is the ED, and the Government of India, that had backed these provisions wholeheartedly. So it's a setback for several petitioners, including the likes of Mr. Karti Chidambaram, Mehbooba Mufti, as well as Mr. Sarwan Singh Fillor. Some of the politicians who've had PMLA cases imposed on them in something that they've been challenging in the courts of law. It's a big setback to those petitioners who said that the PMLA was too ambiguous, extremely wide in its ambit, and could in fact be enforced by the agencies arbitrarily. I mean, let me go across to Bhavtosh Singh for more inputs on this. Bhavtosh, what exactly has the Supreme Court said, and why has it upheld these contentious provisions?
Siddharth, the reason why so many petitions were filed in the Supreme Court was because they challenged Section 3 and 4 of PMLA. 241 petitions were filed, including some very prominent politicians, including Anil Deshmukh and also Karti Chidambaram. They all were arrested in cases of PMLA. They challenged these ruling or sections of PMLA, and they said these sections are completely illegal. Remember, there are several people who have, there are many people who were arrested under sections of PMLA, and they had challenged these sections, calling them contentious and illegal. Now, the Supreme Court has upheld these sections and in fact said that under PMLA, the Enforcement Directorate is well within the law to make these arrests, and they also said as Enforcement Directorate arresting powers are genuine, and that predicate offences ED in fact first make arrest under Section 3 and 4, that ED also carries out investigation under schedule offences, that predicate offences are investigated by ED. Now, it's not that ED has overreaching powers and that ED investigate cases which are schedule offences. Now, these are a bunch of petitions that were filed by several individuals. Prominent among them were Anil Deshmukh and Karti Chidambaram. The Supreme Court has now has in fact upheld most of the powers of Enforcement Directorate, and in fact it allows Enforcement Directorate to probe cases under schedule offences, and ED can now in fact investigate these offences which are in fact schedule offences.
So what does it mean for those netas there, because they seem to be in the dock now? Let me go across to Mr. Nalin Kohli, also joining us here on the broadcast. So Mr. Nalin Kohli, when it comes to those very stringent provisions that were enunciated in the PMLA, sir, that has been upheld by the Supreme Court.
I think we need to understand, and as a practicing lawyer, I look at it a little differently, is that this is not a political issue. Ultimately, every law that is passed by Parliament is subject to judicial review. Judicial review has to be on the corners of the Constitution in terms of whether that law is ultra-virus or is a provision ultra-virus, or does it impact the fundamental rights of any citizen of the country. Now, every citizen also has a right to challenge a provision or seek from the courts, being constitutional courts, being a high court or the Supreme Court as the apex court, to read into the section or look at how that section is to be interpreted, how it is to be operated, if they have a grievance. Now, this batch of petitions, and it was a big batch of petitions, it had been heard for a very long time, had raised several issues about stringency, etc. The issue is not whether it is stringent or lenient. A law is always made for a purpose. And the question is, when the law is framed, is that purpose justified and in the manner in which it operates, is it constitutionally and schematically correct? That's what the court appears to have decided, because I haven't read the judgment yet.
Right.
I'm sure much more structured views will come. But then, eventually, laws are made for a purpose. In this case, the PMLA Act itself, as the name suggests, Prevention of Money Laundering Act, is to prevent black money and laundering of money. Now, those who are prima facie falling into the realm of having laundered money or having proceeds of crime, obviously, are going to face the implication or the implementation of the Act onto themselves. They have their rights within the law, and the Act provides such. But that is part of the court process. But to write off an Act just because it is inconvenient to someone, and particularly those who prima facie are falling into the case of, accumulating black wealth or proceeds of crime, that cannot be the ground for an Act being read down or an Act being removed or revoked or a section being modified.
Mr. Kohli, one more question. Now, there were two other bones of contention on the part of the petitioners. One, of course, is the fact that certain provisions of the PMLA, according to them, place the burden of proof on the accused, and the other, that the Enforcement Directorate does not really have a very laudable record as far as conviction rates are concerned, which indicated, according to the petitioners, that the provisions have been used arbitrarily. Your response, because the Supreme Court appears to not have been convinced by those arguments put forward by the petitioners.
Point out, it's a good question for two reasons. And as practitioners of law, we are in the courts. The track record of a conviction cannot be the basis of whether the Act is being implemented correctly or not, for several reasons. There are murder cases that go on sometimes for 20 years, taking into account from trial to Supreme Court appeal, sometimes even more. Property cases sometimes go on for 20, 30, 40 years. Now, that has to do with the mechanisms and the procedures that are there. That does not mean that the case itself is bad or whatever. And length of time or duration leading to conviction eventually after a long time cannot be the basis whether the section is correct or wrong. That's the first part. The second question relates to the burden of proof. Basic jurisprudence in criminal law is that you are innocent unless proved guilty. But then there are certain acts in which the burden can be shifted, that you are presumed to be guilty in certain circumstances unless you can prove otherwise. Now, several years ago, when the Dowry Act provisions were brought in, the presumption was placed on guilt. So there are provisions in criminal law that you can do so, and they have to be under a set of circumstances and have to be justified accordingly. So therefore, just because the burden has shifted does not make it incorrect. That's the point I wish to make.
Right. All right, Mr. Kohli, thank you very much here for joining us. And